Well, welcome everyone to today's webinar on Carpenter versus United States. I'm really excited to be here. My name is Patrick Walsh. I'm one of the branch chiefs at the FLETC Legal Division in beautiful Glencoe, Georgia. If you ever come to Glencoe, now is the perfect time. It's cool. There are no bugs. There's no snow on the ground. It's a beautiful day, and we're happy to be here. So I'm excited to talk about Carpenter. We've talked about this case once before, and we've been talking about it to every class that comes through here because we think this has the potential to be a significant game changer, particularly not just with tracking, but with government use of technology in their investigations. And so we thought now, we're about 9 months after the Carpenter decision was announced, we thought we'd look at the cases that have analyzed Carpenter, because Carpenter is a troubling case, but it has some internal inconsistencies, and so we wanted to see what the courts were doing it. And so that's why we're here today. For those of you that are new or need a refresher on Carpenter, we're going to do that. And then I'm going to give you some select insight into the cases that have analyzed Carpenter. And I'm not going to focus as much on the names of the cases, because many of the cases are district court cases, so they don't have binding authority. They're not setting the law forever, but it's sure given us a good look into the type of things Carpenter's being affected at. And so that's what we're going to talk about today. So a couple of big questions that came out on Carpenter that we're going to analyze, and we'll tell you what the case is about, but is what happened to cases that of information obtained before the Carpenter decision came out. And is evidence obtained pursuant to a 2703D court order before Carpenter good, or is it suppressible? The second is when does Carpenter trigger? Is it 7 days? Is it less than 7 days? And what is the reach of Carpenter? Carpenter focused on the tracking of individuals, but the language could be broader and apply to other areas. So have courts looked at other areas and applied Carpenter to things outside of the tracking realm? And the answer to that is yes. And so we're going to look at those kind of things. My goal here is to give you an idea of where courts are going with Carpenter, what it means to us right now, and what are the things we can do in our investigations right now or our criminal cases right now to ensure that any changes with courts and Carpenters won't affect the investigation that you're working on. So I'm excited to have you guys here and listen in on this. So let's get started. So let's talk about Carpenter for those of you that it's new information, and a refresher for those that knew about it ahead of time. So Carpenter was a guy that trained, recruited, and organized a crew that did robberies. They did takeover robberies, and if you want to picture what these guys were like, picture your favorite Hollywood bank robbery movie, where they spend half the movie getting the crew and organizing them, and then they execute the robbery, right? That's what Carpenter was doing, a string of robberies. The only difference with Carpenter was they weren't robbing banks. They were robbing cell phone stores, literally Radio Shacks and T-Mobiles and cell phone stores. And so when you think about it, at first you kind of wonder, what are these guys doing? There's no money in cell phone stores. And then you realize if you stole 50 iPhone 10s, you actually have a pretty significant haul. And so that's what these guys were doing, and then we're selling them at swap meets and flea markets and things like that. And there was a string of robberies that occurred in Ohio and Michigan, in the metropolitan Detroit area, but also in Ohio as well. And Carpenter was clearly linked to 5 or 6 of them. Eventually, though, law enforcement, through their investigations, catches one of the guys. And he flips on his co-conspirators, and he gives up Carpenter and tells them that Carpenter was one of the leaders and was the getaway driver. And so they want to shore up the information from this cooperator, so they get something called a 2703D court order. And that's an order under the Stored Communications Act that many of you guys know, and it allows law enforcement through their prosecutors, state and federal and military prosecutors, can go to a court and get an order that requires a cell phone company to disclose certain non-content information. The order allows us to get every person that's called or texted a phone number, and every person the phone number is called or texted. And it also allowed, at the time of this case, cell site location information. And that was the issue in the case. The court issued an order to two companies for 128 days of information on one and 7 days of information on the other. And the issue was for information about everybody that was in contact with Carpenter, to or from, and what cell site locations Carpenter's tower phone was pinging off of. And so you guys all know, everybody has a cell phone, that your cell phone is in constant communication trying to find out where the nearest tower available is. And companies keep records for years of where your cell phones were pinging. And they keep it not because the government makes them, but because it makes sense for their business to have business records about which cell towers people's phones are communicating with. And so the 2703D court order at the time was a statute by Congress that said if a prosecutor submits to the court information that says that obtaining the order is relevant and material to an ongoing criminal investigation, that the court should order and the companies have to disclose not just who's been calling or texting your guy or who he's been calling or texting, but where the phone's been located over the relevant period. And so they got 128 days of information through two different companies that said generally where Carpenter's phone was. And why did they pick 128 days? Because that was the span of the robberies they associated with Carpenter. And sure enough, according, just like the informant said or the co-conspirator said, Carpenter's phone was pinging in the area of each of the robberies. So, Frank, you can't hear anything? Can someone tell me they can hear me? Awesome. Frank Edwards, you scared the heck out of me, man. Okay, great. Thanks, guys. Because I was thinking, awesome. Muffled. Okay. Let's see if I can make it a little better. Feel free to reach out to me, and if the sound doesn't get better, let me know. So here's what happened. They got this court order, and it gave them location information, and it said Carpenter's phone was pinging on cell towers in the areas where each of the robberies occurred. And that's great to know. That, we use this all the time. When I was a prosecutor in AUSA in Las Vegas, prosecutors use it all over the country. It gave you location information. You had 6 different robberies on different dates in different states, and Carpenter's phone is always in the area. It wasn't GPS quality location. It just said he was in the general area. Sometimes it was several miles away, but in the general area. And so they used that to prosecute Carpenter, and they had not just this one cooperator, they ended up having 7 co-defendants who testified against Carpenter, who said that he was the ringleader and leader and the getaway driver, and they had the cell site location information that said these guys are telling the truth because 1, Carpenter was in communication with them, and 2, Carpenter's phone was in the area of the robberies when the robberies occurred. And so that's what happened. And so they convicted Carpenter. And his attorney tried in pretrial to suppress the evidence, not just the evidence of the phone conversation or that there were phone communication, but specifically the evidence of cell site location information. And what he tried to argue is that when the law enforcement, when the government got information about where Carpenter's cell phone was, that they should not have used a court order, that they should have used a search warrant. And that was the key issue in the case. They lost at the trial level and went all the way up to the United States Supreme Court. And that was the question. And so let me stop with this, because this is one of the big issues about how other courts have interpreted Carpenter. So the facts in the Carpenter case are this. Carpenter had a cell phone with a cell phone company, and as part of his agreement, he knowingly or unknowingly agreed to allow the cell phone company to track him because they needed to know where the phone was, because if someone called a Carpenter's number, they had to route it to the tower near where his phone is. And to do that, they had to track the phone. And so the cell phone company was tracking Carpenter pursuant to their agreement with him. And the government didn't tell them to track Carpenter. In fact, the government didn't tell them to keep records of the fact that they tracked Carpenter. The cell phone company kept these records because it was part of their business, and it made sense for their business to keep these records. What the government did was get a court order pursuant to a congressional statute, the Stored Communications Act, that said that if the cell phone company had these records that showed where Carpenter's cell phone was during the relevant periods, that they had to turn it over to the government. And Carpenter's attorney was saying the Fourth Amendment should protect the information about where Carpenter was located. And so this, what we thought of was a search under the Fourth Amendment, was didn't apply in this case. We knew a search was, there were two ways to define a search, a Jones search and a Katz search. The Jones search came out of a tracking case where the government directly tracked Jones. In fact, they put a magnetic tracking device on Jones' car. And the court said in the Jones case that it is a search if the government physically touches a person, house, paper, or effect of an individual in order to gather information. And for Jones, when they slapped the tracking device on Jones's car, that was a search. But in Carpenter's case, the government didn't slap any tracking device on Carpenter on his phone. They didn't install any device because they weren't tracking him, because the phone company was tracking him, right? So the other type of search that we know about, the one we all grew up with, was a Katz search. And the Katz definition, as you all know, was anytime the government intrudes into an area where there's a reasonable expectation of privacy, that's a Fourth Amendment event, and that's a search under the Fourth Amendment, and the government needs a warrant or an exception to the warrant requirement to do it. But here, Katz didn't seem to apply either, because the general rule was once an individual gives up information to a third party, they lose their Fourth Amendment protections because they can't expect privacy in something voluntarily given to another. And here Carpenter exposed his location to the phone company, and the phone company collected records of where he was, and they stored it in their business files. And Carpenter didn't have an expectation of privacy because the phone company could go in those records anytime they wanted to. And so it didn't really fit as a Katz search either. Carpenter didn't have any ability to tell the phone company to erase the records or stop tracking them or not look at them, because the records belonged to the telecommunications provider, not to Carpenter. And so it didn't seem to fit in a Katz search either. And so the trial court and the appellate court declined to suppress the evidence, and then it went to the Supreme Court. And so let's see what the Supreme Court has to say. Calvin, Mr. Meyer, you got a question? I'm happy to talk to you if you do. You can write it in the chat button. Feel free to ask questions, folks, and we'll answer it. So the Carpenter case, the Supreme Court actually suppressed the evidence. And the way they did it was really new or novel. They started with an idea that I think we can all agree with, and they talked about how detailed cell phone records can give us. And they were talking generally tracking information, where they said that the tracking of people through their cell phones, that can give you detailed encyclopedic information, and it's effortlessly compiled. And what it means is government, by getting this information, the government can learn very detailed information over vast periods of times about the person who's holding that cell phone. And the retrospective quality of the data, they said, gives us a category of information that was otherwise unknowable. And it really is a significant thing, which is why we wanted it. At any given point, law enforcement can go back in time and learn where a suspect has been. And so when they get an information about a suspect who had engaged in criminal activity in the past, through a low standard where they don't need a search warrant and they don't need probable cause, they can get an order from a court to find out where that person was been. And the limitation is how long ago is relevant to the crime and how much information the company stored. And according to the case, these telecommunications companies store up to 5 years of information. And the court was troubled by the idea that at any point law enforcement, once they had a reason, once it was relevant to a case, they could go back and figure out where pretty much any American, right, any American that had a cell phone, went for the last 5 years. And so that was their concern in the Carpenter case. And so they were worried about it. They decided then that the evidence should be suppressed and that law enforcement needed a search warrant in order to get the information about where Carpenter's phone was located. How they got there was by holding that every individual has a reasonable expectation of privacy in the whole of their physical movements. Every person has a reasonable expectation of privacy in the whole of their physical movements. And that anytime the government wants to get 7 days or more of cell site location information, that they need to get a search warrant or have an exception to the warrant requirement. And so this was, this is straightforward holding. We can't use the 2703D court order to get cell site location information if we're getting 7 days or more. However, how they got there is a head scratcher, because they found that the Fourth Amendment protects information of an individual contained in the business records of the company. I mean, that's exactly what they held. They held that the Fourth Amendment to the Constitution protects Carpenter's records of his physical movements, no matter where they're stored. And so it didn't matter that Carpenter was in public locations. It didn't matter that the records never belonged to Carpenter. It didn't matter that Carpenter signed terms of service that allowed the company to track them. They said because the information of where you've been 24/7 for 7 days or more is super private information, that the Fourth Amendment protects it no matter where these records are located. And so that's a whole new thing. This is a whole new type of idea that you can have Fourth Amendment protections because the information is private and should be protected, not because the person has done something to the information to keep it private. Or put another way, if I wrote out a confession to a crime and put it in my own home, I would have Fourth Amendment protections because they're my papers, they're in my house, and I have Fourth Amendment protections in my house. Law enforcement would need to get a search warrant or have an exception to the warrant requirement to go into my house to get that confession. However, if I took that confession and I put it in my neighbor's house, I would lose my Fourth Amendment protections over it because I don't have a right to expect privacy in the house of my neighbor. And so I would lose any Fourth Amendment protections over it. But the court is saying if I had 7 days of detailed information about where I was 24/7, that I would have an expectation of privacy in it. I would have Fourth Amendment protections, whether it's in my house or my neighbor's house or the business records of a cell phone company that's tracking us. And that is a whole new thing, an area of the law that they've never dealt with before. And so we have to kind of figure out what this means. Then they asked, is 7 days the answer, unless if we do it 6.5 days, are we good? The court focused on the orders in this case, and there were two orders, one where they obtained 128 days of information, and one where they asked for 7 days of information, but only got 2 days. And they said that 7-day order was too long, and therefore you needed a warrant to get 7 days of information. But then they specifically said, they specifically said they were not saying, they declined to say that less than 7 days is okay. So we knew 7 days was bad, but 6 days could be too much too, and 5 days could be too much too. They also talked about the idea about whether or not you could waive your right to expect privacy. And they said you could lose your reasonable expectation of privacy, but they said it required something more than what Carpenter did, which is sign up for a cell phone contract that had as one of its functions, the right of the cell phone company to track it. And so they put up a test, and then they used the phrase no mechanical application. And this is the test on the screen. The test said that they're going to look at 3 factors. They're going to balance to decide if someone loses REP, and one is the extent they knowingly shared with another. 2 is the nature of the information sought, meaning how private is the information in and of itself. And 3 is any limitations on legitimate expectation of privacy concerning the contents. And I'm not even sure what that means right now. We haven't had a case talk about that yet. But then they also go on and say there's no mechanical application of this test, which means, to me, the Supreme Court can use these guidelines or discard them if they want to figure out what to do. But clearly what they're saying is you can lose this REP that Carpenter had, but you have to do something explicit or intentional or purposeful in order to do it, and merely signing a contract that allowed a cell phone company to track you is not enough. Okay, so what do we have? So where we were at with Carpenter right now is that 7 days or more of information about where a person has been is protected by the 4th Amendment, and you either need a warrant to get it or an exception to the warrant requirement. And that's really important. And so it applies to 2703D court orders and cell site location, but any other time we're getting 7 days or more of information about where someone's been 24/7, that's protected by the 4th Amendment. And we need a warrant or an exception to the warrant requirement. They were clear to say that exceptions to the warrant requirement apply. And so you can use them just like we can use them for other areas. So the DOJ guidance that came out the same day the court came down said, basically, don't use 2703D court orders to get any amount, any length of location information. They said use a warrant when you can. That's where they went with. But clearly there's some short-term amount where we can collect information about someone's location that's not part of, or that's not prohibited, that's less than a search. Because the court focused on the idea that if you collect non-stop information about a person's location, you don't just learn where they've been, you learn a bunch of stuff about them that is private and according to the court should be protected under the 4th Amendment. For example, if you follow someone 24/7, you're going to learn where they go to church and whether they have certain political associations, what social clubs they go, where they live, where their girlfriends live, and a bunch of, you may learn about what doctors they visit, which might tell you what medical conditions they have, and these kind of things that are super private. And that's really what the court was getting at. It wasn't just the location information, but it was the information we could use, we learned based on that location information. And that's really why we wanted the information, right? We wanted the information in Carpenter to show not just where he was, but that he was near the store and was one of the people that was helping rob the bank. And so, but we have this issue now about where is the reach of Carpenter? Because if it's really just, anytime we want 7 days or more of information about someone 24/7, then okay, we'll deal with that. But because of Carpenter is so broad and the way they arrived at saying this was a search, the idea that it was a search for the government, a search of Carpenter when the government asked the cell phone company for records, that's a whole new thing. And we also want to know what happens to all the 2703D court orders that we got before Carpenter, right? We use these all the time. We would get them regularly in Las Vegas with location information. And so if I got an order and I got information from the cell phone company on June 21st, the day before Carpenter came down, can I use that at trial? And if I had prior convictions or prior cases where I've used that information that are still on appeal, do we have to retry those cases? So the first question we have with Carpenter is retroactivity. What about the stuff that occurred before June 22nd? And we know if you got location information from a 2703D court order, from anything that's not a search warrant, clearly if you got 7 days or more of information after June 22nd, 2018, you're violating the Fourth Amendment, and that information is not good. But what if you got it on June 21st? And so we haven't had every circuit in America, but everyone that has looked at it, and several have looked at it, have held that Carpenter is not retroactive. Or to put another way, that evidence obtained before their decision is admissible at trial. And this is a great, audio is cutting in and out on some, okay. Let's see if we can make this better. But this is a great point. So we're good if you have these court orders before June 22nd, 2018. This is really good news for us. And it makes sense, actually. So specifically the circuits that have dealt with this is the Second Circuit, the Third Circuit, and the Seventh Circuit, among others. District courts and other circuits have ruled at it too, and all of them so far said Carpenter is not retroactive. The idea makes sense because law enforcement and the prosecutors had a congressional statute that said if we follow the statute, we can obtain this information. And we had been using that statute and obtaining this information literally since 1986 with no issues. And so excluding the evidence obtained by using a statute that had been around for 30 years should not violate or should not require the exclusionary rule. And so far the big issue is good. We're going forward, we can't use this information, we can't get it through a 2703D court order. We need a search warrant to get detailed location information for many days. But the stuff we got before Carpenter came out is admissible at trial, should not be excluded. So that's good news for the first step. And of the 250 cases that have interpreted Carpenter since it came out June 22nd, and think about that, I mean, there are more cases that interpreted Carpenter than there are days since Carpenter came out. Most of the cases that interpreted Carpenter deal with retroactivity, and while I haven't read all of them, I've read the Federal Circuit ones, and they have all held exclusionary rule doesn't apply. Carpenter is not retroactive. Evidence obtained through these orders prior to June 22nd are admissible. Okay. The second big question we had with Carpenter was, is less than 7 days of detailed location information okay to obtain without a search warrant? Carpenter specifically said that the order where they asked for 7 days or more violated the Fourth Amendment, and you needed a warrant for that. And then they said they would not say whether less than 7 days was okay. And there's some reason to think that less than 7 days is still not okay. And so here's the facts of the Carpenter case. So there were two orders in Carpenter. The first one they sent to a cell phone company where they asked for 150-something days of information. And the cell phone company came back and said, we have 126 days of information, and here's the order. And when the Supreme Court looked at that, they said receiving 126 days of information violated the Fourth Amendment. And so they didn't focus on what they asked for, they focused on what they got. When law enforcement looked through that information, they realized there was a missing 7-day period. And then they learned that that's because the cell towers during the robbery were held by another company. And so they sent to Sprint a request, another 2703D court order for 7 days worth of information. They asked for 7 days worth of information, but when Sprint came back, they said, we don't have 7 days, we only have 2 days worth of information. And so the court had a choice, really. They could have said 7 days is no good, or they could have said 2 days is no good, right? Because the government asked for 7, but only got 2. And in the longer warrant, they did not focus on what the government asked for, but only on what the government received, the 126 days. On the shorter warrant, they did the flip side, and they said 7 days of information is too long. They could have just as easily said getting 2 days worth of information is too long. The facts would have permitted them to make that decision, and they chose not to. So what does that mean? It could mean absolutely nothing. We're trying to read the tea leaves here, but to me it suggests that the court thought that 2 days was too short of information, and their only other choice was 7 days. So that probably the most likely thing is less than 2 days might be okay. But there is between 2 and 7 days is the part where the court thinks is the problem. And you see how hard this is? I mean, we have to try to guess for how long is too long. It's clear that the court's focus was gathering gathering enough publicly available information without a warrant that you learn private stuff was the issue. And the issue was the government being able to use this location information and interpret it to learn private things about the individual being tracked. And so short periods of monitoring that do not provide information about private things about the person are probably still okay, or at least are not the point of the Carpenter case. And so there's some short-term things are okay. The examples that I would give that I think are permissible still would be if you had a tracking device on an individual who's driving a load of drugs, right, from the border to a stash house. Doing an 8-hour drive from Nogales, Arizona to a stash house in Las Vegas, Nevada is not going to tell law enforcement anything private about the driver. They're just tracking the vehicle. And so that wasn't the thing that Carpenter was upset about. So short-term tracking like that is probably okay. Now, I say it's probably okay, but I would also tell you if I were the AUSA on the case, and I would ask you if you had probable cause and tell you to get a warrant anyways. Because we don't know where we're at. But the 7 days thing, the case itself suggests that less than 7 days might still be concerning. But given the facts that 2 days was not where they wanted to hang that case on. Now, there have been 0 cases that have interpreted this issue about how long is too long. Part of that is because of the guidance from the Department of Justice. No federal assistant U.S. attorneys are getting location information from these 2703D court orders. So therefore, it's left to the state courts or the military courts starting January 1st to see if they can get location information and if they're trying to do it for short periods of time. So we don't have this case yet. We know 7 days is no good, but less than 7 days is probably no good as well. And how much less, we really just don't know right now. So we'll update you when we learn more information about that. Here's the other part of Carpenter I think that really we have to think about. Is the court focused on the tracking of an individual, but that doesn't mean that Carpenter cannot be used for other purposes. What the court did in this case was they found that a particular type of information that tells where you've been 24/7, is so private that it deserves Fourth Amendment protection, no matter where it's found. And so they've never made a decision like that before. Before that, things were protected by the Fourth Amendment when the holder did things to keep them private. But here, the tracking of your physical movements is protected even if you do it in public, even if it's stored in the records of another person. And so that's a new thing, that there is a category of information that receives Fourth Amendment protection because it is private. And so the question now we have is there any other type of information now that is so private that it deserves this special treatment under the Fourth Amendment? And as you would suspect, defense attorneys all across the country are trying to argue that yes, information that they had is equally private and deserves this special protection. So we're just getting an idea of the types of cases that are moving forward. But anytime law enforcement is using technology to gather information without a search warrant, were open to the idea that the defendant, after he's charged with the crime, will try to suppress the evidence, arguing Carpenter to do so. And so that's where we're at. And so we're looking, there's a couple different areas that the courts have already decided. Like I said, there have been 250 cases analyzing this. One of the big one, or the highest number with 4 cases, is video surveillance. And video surveillance was challenged even before Carpenter under reasoning in the Jones case. But as soon as Carpenter came out, 4 smart defense attorneys tried to argue it in their case, and we already got 4 decisions. For whatever reason, 3 of them came out of Wisconsin, and 1 of them came out of Illinois. They're all district court cases, and so the rulings here are not binding anywhere else in the country. But each of these 4 cases analyzed whether video surveillance, in these they were poll cameras, fixed surveillance. In each of these cases, they were surveillance on somebody's home. They were trying to find out the comings and goings of people's house, either the front of the house or one that was actually in the neighbor's house, looking down at the neighbor's backyard. And the question was, should Carpenter cover this? The attorneys had a reasonable argument. Their argument was, the tracking of us nonstop is protected under the 4th Amendment, that long-term monitoring of everything going on in our house is equally private, according to them, and so that should be protected too. And so the court considered it and analyzed how similar these are. Ultimately, they said that they declined to suppress the evidence of the long-term use of video surveillance on an individual's home, saying because it didn't give us information about where the person was when they were not at home. So, but the fact that 4 cases have already brought it up means there's an idea and an argument laid out here that can be tried in cases everywhere else. So if you have poll cameras in a public location looking at only public things, but there for a long period of time, you're going to have a suppression hearing in your case. If you get a search warrant for it, even if you're in a public location looking at public locations, then you're not going to have a suppression hearing. And we don't know what other courts will do, but right now, so far, these 4 cases held that Carpenter did not prohibit the long-term monitoring of someone's house through fixed surveillance. And they even cited a part of the case that said that tried to limit Carpenter, that said that we do not disturb or call into question conventional surveillance techniques and tools such as security cameras. So Carpenter gave us one paragraph that limited its application, and that was one of them. And so far, video surveillance is not restricted by Carpenter. However, because it's being raised, expect it to be raised in your case. Okay. The next big area that people did is they went to and looked at the Stored Communications Act, and they said, if Carpenter applies to the tracking of our physical movements under 2703D, we should argue that it applies to the other parts of the Stored Communications Act. And so, as many of you know, the first section of the Stored Communications Act allows you to get subscriber information, which includes IP addresses of individuals. And so there were 2 district court cases that came out on this, and in those cases, the question was whether Carpenter prohibited the obtaining of subscriber information and the IP addresses of individuals. These were both child pornography cases, and law enforcement got information that a certain IP address was linked to obtaining child pornography, used a subpoena to get the IP address and the subscriber information, the address located with that downloading of child pornography, then took that information and got a search warrant, executed the search warrant, and arrested the suspect. The court handled these things pretty succinctly, and in both cases, the court held that Carpenter did not implicate this. Basically, they said, look, knowing what your IP address is not implicated by Carpenter, and oh, by the way, this is clearly something, your address, your subscriber information, that you voluntarily give to the cable company in this case. Therefore, even if Carpenter was implicated, these individuals had given up, lost their reasonable expectation of privacy in that information. So again, you might get this issue, but I think these two cases have a very clear explanation of why Carpenter would not apply to them. All right. The next one was one that I didn't see coming, but it makes sense and suggests an even broader application of Carpenter, or at least what defendants will be seeking to do. So in this case, it was a defendant was, again, child pornography case, and a defendant had communicated with another person, sent an email requesting information that was relevant to the child pornography. And law enforcement got a search warrant, and they got a search warrant not of the defendant's email account, but of the person he sent the email to. And so they got a search warrant of that. They got the information, and lo and behold, in this third person's email address was an email that was sent from the defendant to the third person, and it was criminal. And so they prosecuted the defendant and used this email. And the defendant wanted to challenge the search warrant that obtained the emails from another person. And so we know this is a classic standing issue. And for law enforcement out there, standing is the idea that when that you can only assert your own Fourth Amendment violations, and you cannot raise the issue and claim that the violation of someone else's Fourth Amendment rights. And so this defendant wanted to do just that. He wanted to argue that the search warrant that got information from somebody else's email account violated the Fourth Amendment. And he argued that Carpenter should let him do that. And the way this argument works is that Carpenter found that Carpenter had Fourth Amendment protections in something that he shouldn't have had standing to raise: the business records of a company. And the argument here was that meant that the standing doctrine, the third party doctrine, doesn't apply as robust as it did before, and therefore this defendant should be able to assert someone else's Fourth Amendment rights. And so that's a little bit of a misreading of what Carpenter says, but when you think about their ability now, that they now can use Carpenter in an area that's not discussed in the case to try to expand their ability to attack everything law enforcement does, and to try to attack the violations of other people's Fourth Amendment rights if information is obtained against the defendant. And so while this one was a straightforward one with the email account, this is a sign of more to come, that creative attorneys are going to be using Carpenter to try to attack other Fourth Amendment, other searches done by government of people who are not the defendant. And so we got to figure that out. That's going to be out there, and you have to start thinking about how law enforcement obtains information, and that Carpenter may be used basically to bootstrap Fourth Amendment arguments of other individuals to the defendant. This court found there was no standing, but who knows what the next court will do in other cases. So that really was the big areas of cases. The retroactivity one was the big decision. The video surveillance one will keep coming up. But law enforcement still have to be wary, because Carpenter is going to be used, and people are going to argue about its application to new and other ways. And really what we have now is defense attorneys will be arguing the bulk of the Carpenter case, which talks about how the Fourth Amendment protections have been eroded, how when law enforcement uses technology to gather information without a warrant, that we are lessening the Fourth Amendment protections, that they're less now because of technology than they were when the Fourth Amendment was enacted. And these broad strokes, and the prosecutors have one paragraph to respond to that. Now, one paragraph basically says the court, while they announced this huge decision that says that Carpenter has a Fourth Amendment right to information because it's so private, even if it's held in the business records, we have one little paragraph where they said, hey, it sounds like we're announcing a big thing, but we want to make we're saying our decision is narrow. And that's what they said. Our decision today is narrow. And then they said that the case law that said that obtaining bank records through subpoenas is still good law, and the case law that says getting cell phone information is still good law. It's the location information that we need a search warrant to get if we're getting long-term, many days worth of location information. But it really is something where there's plenty of information, plenty of fodder in Carpenter for defendants to argue that it should be expanded well beyond just the tracking. So what can you do? Well, first, to understand, we don't know where they're going next, because a creative attorney is going to find a way to make Carpenter applicable, and they're going to use it anytime they think that they have information that is super private information, as private as the tracking of your physical movements. And if they do, they can argue that Carpenter should apply to them as well. When this comes up is when law enforcement uses technology to gather lots of information without a search warrant, particularly when we're getting it about one individual. And so if you want to defeat this purpose, one is you can get a warrant, right? And I was just like that prosecutor that everybody hated, where I would always say, if we have PC, let's get a warrant. Even if we think it's legal anyways, we get a warrant. And nowadays it's even more so, because the Supreme Court is moving to requiring law enforcement to get search warrants more than we currently do. And so if you get a warrant, no matter where the Supreme Court goes next year or the year after, our case is solid, our evidence is admissible, because the worst case scenario, or the most restrictive case, is for us to get a warrant. So what are some of the solutions? Is this: get a warrant. The other thing to do is get good, clear consent. Because remember, even if the Fourth Amendment applies, then the judicially recognized exceptions also apply. And consent is a great one. Good, clear consent for it, we'll get there. The other issue we might do is collect less information. And this is a little controversial, but when you think about it, in Carpenter, to prove the case initially, they didn't necessarily need 128 days worth of information. The robberies occurred on 6 days, and they could have asked for those specific 6 days. Why they didn't do that is because we didn't think we needed to, because we had a statute that said we could. So, but maybe initially collect less information until you have probable cause, and then get a search warrant to collect the broader information. And so asking for short-term information, whether it is location information or through other technology, might be the way to go if the limited information can give you what you need to get a warrant, and then go back with a search warrant to get broader information. This is really where we're at, because we're in the early stages. We're 9 months in, and we already have 250 cases cited to Carpenter, and we already have examples like the ones I showed you here of attorneys trying to expand Carpenter to other areas, and it's just going to keep going. And so if you're using technology in investigations without a warrant, when it's charged, there will be a suppression hearing, and that suppression hearing will partially be about Carpenter and trying to expand Carpenter cases. And so far we're winning them, and that's good, and so far courts are limiting it just to the long-term tracking of individuals. But if you get that search warrant up front, then you're not going to have the suppression hearing at all, and you can go straight from the arrest and the charging of the individual to their pleading guilty or to trial. But if we obtain the information without a search warrant, it's almost malpractice now for attorneys to not try to see if they can find a way to make Carpenter apply to the use of technology. All right, that's where we're at today. I'd be happy to answer any questions. I wish I could give you more specific information, but as we get more cases in other areas, we'll definitely talk about them too. And if you have any other topics that you're interested in, please let us know, and we'd be happy to do a topic of interest of you guys. I'll go up to the front so you guys can see my email address. Feel free to email me. Also on the bottom left-hand side, there is a certificate and the slides. Feel free to use them. Be happy to send you information on any specific cases that you might be equally interested in. It's always a pleasure talking to you guys, And we're happy to do this again. We had a little break because of that little government shutdown, but we're glad to be up and running, and we'll do more. Stay tuned, and look forward to seeing you guys again. All right, definitely, Brian, we'll do a drones one again. We got a guy, Bob Coughlin, who is our drone expert. We got a new guy here who also has some interest in drone stuff, and so we can definitely talk about that. Thank you all for paying attention. Great attendance this time. We were really excited about it. Manny, you got it. Coffee and donuts are on me. So, of course, you have to come to Glencoe, Georgia to get them.